We will now start with verses from the holiest of holiest books, and I invite Farhan Musin to recite a few verses today. Farhan.
Assalamu alaikum. I'll be reciting a few verses from Surah An-Nisa. أعوذ بالله من الشيطان الرجيم. بسم الله الرحمن الرحيم. فليقاتل في سبيل الله الذين يشرون الحياة الدنيا بالآخرة ومن يقاتل في سبيل الله فليقتل أو يغلب فسوف نؤتيه أجرا عظيما وما لكم لا تقاتلون في سبيل الله والمستضعفين من الرجال والنساء والولدان الذين يقولون ربنا أخرجنا من هذه القرية الظالم أهلها واجعل لنا من لدنك وليا واجعل لنا من لدنك نصيرا الذين آمنوا يقاتلون في سبيل الله والذين كفروا يقاتلون في سبيل الطاغوت فقاتلوا أولياء الشيطان إن كيد الشيطان كان ضعيفا صدق الله العظيم. I'll also be reading the meaning of these ayahs. And what is with you? You do not fight in the cause of Allah and for oppressed men, women, and children who cry out, Our Lord, deliver us from this land of oppressors. Appoint us a savior. Appoint us for a helper, all by your grace. Believers fight for the cause of Allah, whereas disbelievers fight for the cause of Shaitan. So fight against Shaitan's evil forces. Indeed, Shaitan's schemes are weak. Sadaqallahu al-Azim.
Sadaqallahu al-Azim. Jazakallah. Thank you very much, and God bless you, Farhan, for that wonderful and powerful rendition. An act of terror outrages the moral person in us, prompts institutions to act and deliver justice. Civil society condemns it and protects the victims. Now, what do you do when the very same institutions and frameworks that is meant to protect commits the act of terror and justifies the unjustifiable by fabricating history, twisting narratives, corrupting lawmakers, circumventing laws, and even legislating laws to further a sinister sectarian agenda? This is what happened in the case of Babri Masjid that was illegally demolished. My name is Naeem Badiuzzzaman, and I work with Strive, a British Muslim advocacy group committed to creating a more equitable society. Our special event today is a part of our ongoing campaign of remembering and recalling Babri Masjid. Our key talk will be delivered by Abdullah Azzam, who I will introduce shortly. But before that, you will see a special video that showcases the lies and fabrications used to create the narrative that led to the mobilizing of the mobs, the false premises of a birthplace of an important religious icon, the denial of the pogrom that followed, the justification of the violence, and the almost trivializing the pain of the victim, the political dividend that one gained from it, and the final nail in the coffin, judicial protection to this act of terror by protecting the conspirators and leaving the Muslim victim defenseless and sadly now hopeless. Abdullah Azim will now play 2 minutes from the video and also make available the link to the full video on the chat window.
India's top court has given its verdict on the disputed Ayodhya religious site, which is
1992 Babri demolition case, the so-called criminal conspiracy. The judge S.K. Yadav
accused in the 1992 Babri demolition case.
If there is one recurring subject about India today, it is about the country's relationship with its Muslim citizens. But the truth is, the treatment of Muslims in India has remained violent and discriminatory since 1947 itself. And if there is one moment that encompasses the length and breadth of India's treatment of its Muslims, it is the demolition of the Babri Masjid. The Babri Masjid was built in the late 1520s on the orders of the Mughal Emperor Babur. Nearly 3 centuries later, the mosque and its historical existence became a focal point of contention in the country, and a defining contender to India's secular fabric.
So as far as historians are concerned, their record is a straight one. It's quite clear that Babri Masjid had 2 inscriptions, not 3. In neither inscription was it said that that any temple was destroyed, because when Muslims built mosques on temple sites, they usually proclaim the fact, unfortunately. But in this case, there is not the slightest mention.
The disputes begin with a plea in a court of law. A Hindu priest seeks the permission of the Faizabad district court to set up a canopy outside the mosque. The plea is dismissed.
The dispute in terms of legal debate started in 19th century. There were 3 suits filed. In all the 3 suits, the Muslim claim was accepted. The Hindu claim was about, a raised platform outside the mosque, but even that was not accepted as the birthplace of Lord Rama or the ownership of Hindus. And ideally, as per principle of res judicata, once a dispute has been finally decided by the court, it cannot be reopened.
In 1853, the first clashes between Muslims and Hindus erupt, with each party contesting the rights to the land. Members of the Hindu community believe that the mosque was constructed over a temple, and the site was the birthplace of Lord Ram, a central figure to the faith.
It has no evidence at all that it was ever a temple. As far as the archaeological survey is concerned, when they dug up actually, they came across a westward wall, which is usually there in a mosque, particularly one-walled mosque of that time, and there was a mihrab in it. But they actually dismissed that.
Faith is irrelevant to determine property dispute. It was purely a civil suit, which...
Thank you very much for playing the first few minutes of a very powerful video that actually methodically charts the history, and more importantly, the history of the false narrative behind what has now become a tragedy that will continue to plague not just Muslims, but the country and our standing across the world. I'm now going to invite Shaheen Abdullah, who and the team was behind the video, to speak to us a little more about this. Shaheen, over to you.
Thank you so much. Thank you for inviting me again. I didn't know that I would be invited again. What would I say? It's not a complete video. I don't know how we can chart the how we can put things about Babri Masjid in like 5 or 10 minutes video. We tried to make it into 5 minutes, but it didn't stay. It went around 30 minutes just to explain what all kind of factual errors happened. Like, we are just talking about the constitutional laws and the archaeological facts over here. We are not going into the details about how it was demolished, how it was raised down by the people, and the violence that that happened afterwards. So we are just trying to simplify. We are just focusing on just 2 parts that Archaeological Survey of India have already said that this disputed land, there was no structure, there was no temple structure beneath the masjid. And on the constitutionally, we are talking about the Professor Faizan Mustafa is talking about how it is illegal. So he talks about, categorically speaks about how all the judicial system from the Allahabad court to Supreme Court, how it has categorically rejected Muslims' plea. At the same time, by Mary, the faith of Hindus, it was the land was given to Hindus, and how even the people behind it, the conspirators like L.K. Advani and other people were acquitted, even though evidently people saw what happened. And for me, talking about Vajpayee is also something that we have to include, which I couldn't include because people were not speaking about it. My speakers were not talking about it. He gives a speech before the night before Babri Masjid was demolished. He like vaguely speaks about leveling to ground. He speaks about, I can't stay here, I have to go to Delhi. You guys are equipped with stones and things. So he gives a hint, and it was actually circulated by the intelligence agencies. And yet CBI, with all its evidence out there in the daylight, just goes away and tells that these people were executed. It was still in the moment, it was a momentarily act, and it was not something they have planned actually. So that is Babri. Babri happened after Babri only we were born, but we still have the burden of speaking about Babri every year. I don't know how it happens. And before I go, I just want to say this. This month, December, I was working on this video since the beginning, in the early days of December, and we had a lot of Muslim tragedies happening in India right now that we had to deal with. You have Love Jihad happening at one point. We have anti-CA movement commemorating anti-CA movement. You have UP violence coming in. You have all India violence coming in. You have Kashmir issues. So actually, for past 1-2 week, I was in this chaos that which Muslim tragedy should be prioritized and speak up first. Like I was telling Shane K. Moidoni, who assigned me this small video work, I was telling him, I don't have the time. I have to go back and forth with this, which one should be prioritized. And at such a moment, with so bleak future for minorities in India, I think a talk like this is very, very important, and it is something that needs to be addressed. The Islamophobia, the laws of the land in India right now, and I think so. Azam is the best person to speak about it. I don't want to take away anybody's time. Thank you so much again, Steve India, for this chance. I know the video has so many technical glitches, but thank you for accepting it, and I hope people watch it because the content is very solid for it. So leave the technical parts aside, watch the content and speak about recall Babri. Thank you so much.
Thank you, Shane. I mean, this is definitely an act of terror that we need the world to know. And what is doubly saddening is that unlike acts of terror, this was not condemned. And unlike acts of terror, no state support or institution actually stepped in to deliver justice to its victims. So thank you very much. Now over to our key session. Abdullah Azam, who I spoke to you about earlier, who will be the key part of our session today, completed his LLB from Aligarh Muslim University, where he was also president of the Aligarh Muslim University Students' Union. He was involved in student mobilizations and protest movements. He completed his master's in law from King's College in London and is currently pursuing his doctoral research at the Department of Law at Oxford University. His research in particular focuses on the anti-terror legislations in India and how it impacts Muslim lives. He has appeared on numerous political and media platforms to speak and comment on issues pertaining to the Muslims in India. The format will be, he will speak for about 35 minutes, followed by a 15-minute Q&A session. And for the questions, please do feel free to share the questions in the chat window. We're not very precious about having only the questions written down after the session. By all means, go ahead. I will try my best to accommodate as much as I can. And if there are those who want to ask the question directly, I'm happy to let that also happen as long as you let me know in advance. So over to Abdullah, who will now be spotlighted in the video now. Thank you.
Assalamu alaikum.
Alaikum salam.
Yeah, so first of all, I would like to defend the topic Islamophobia here, which is not very much in use in India while describing the animus and the discrimination and prejudice against Muslims in India. So there is a reason why we chose the topic, the title as Islamophobia and the law. And I'm not the best person to discuss the Babri case. I would not complicate the Babri case, which is very simple. That there was injustice, that on the face of it, an illegal act was justified and got legitimacy through the code of law, which was supposed to to punish the culprits. So why Islamophobia? And the first and foremost reason to use Islamophobia here as a concept is to free the phenomenon, the multifaceted phenomena of animus towards Muslim from the bogus vocabulary of bogus vocabulary and binary of communalism and secularism, or you call it discrimination. So because it conveys, when we say that there is communalism, when we say there is discrimination against Muslim, there is some prejudice against Muslims in India. It conveys that the phenomena is a fringe phenomena, is a minority phenomena. While on the other hand, the fact of the matter is that the animus towards Muslim is not fringe, is not irrational. Rather, it is strategic. It is very rational. It is very inherent in the idea of India, and it is important to understand how this is very much inherent in the idea of India. Anti-Muslim sentiment and the othering of Muslims in India is very much inherent. To substantiate this point, that how this animus, this prejudice against Muslim is inherent in the idea of India, I would look first into the Constitution of India, and second into the founding moment when the nation state or India was evolving, that is 1946, 47, 48, 49. What was happening then? And then I will look into the security legislations or the emergency legislations, how the emergency legislations were drafted, the text of the legislation and the application as well, how it was applied for othering Muslims in India. So, because what happens when we feel and when we express that that this is discrimination against Muslim, or that Muslims are being targeted and marginalized, that the liberal voice will always push us that your side of the struggle is the court of law, your side of the struggle is law, and sometimes the side of the struggle is the politics or the political. But it is important to understand that the law itself is the place from where this othering is taking place, or I mean, it is very important to understand that the fight or the site of a struggle is not legal, it's not political, is also epistemological, which I would come later. So first of all, the Constitution of India, and the very first article, which is Article 1, which says that India, that is Bharat, would be is a union of states. So the word Bharat has some significance here. And when we look into the Constituent Assembly debate, it was said that Bharat should come before India and India should come later on, because it denotes and it signifies the sense of belonging among Hindus, a sense of ownership among Hindus, that is a Bharat which is now freed from foreigners. And foreigners, just not only British, but the Muslim foreigners as well. Because in Hindu scriptures, there was a description about Bharat Varsha, the subcontinent, Indian subcontinent. So when we use the word Bharat in the Constitution and the very first article which says India, that is Bharat, it gives a message, that a sense of ownership among Hindus, that this land belongs to them. They have a moral and natural claim over this land. And I mean, this is very much expressed in the Constituent Assembly debates. I mean, if you look into what Jagat Narayan Lal from Bihar, the Constituent Assembly says, and other Constituent Assembly members, that Bharat gives a sense of ownership to Hindus. And the other part is the union word, Because what happened before the Constituent Assembly sat and before the partition, before independence, that Muslim League was demanding a federation of states in India, and federation of states with all the units having autonomy, except in few issues, a few issues such as communication and defense and foreign affairs, etc., etc. So they were kind of, the Constituent Assembly members were kind of relieved that now Muslim League is gone and India is now again a unit, one unit, a monolithic unit with a strong center. And this centralizing tendency is very much, totalizing and centralizing tendency is very much part of the Hindutva politics and the Hindutva group then and now itself, that it should not be, a strong federalism never suits Hindutva ideology. So they were kind of relieved that now Muslim League is gone, Pakistan is there, now India should be one Hindu nationhood. The idea of Hindu nationhood is now materialized through this definition of India, that is Bharat is union of states. So yes, the very first article has this message, and this is very much expressed in the Constituent Assembly debate, union and the word Bharat. Before I go further, I would like to refer or to take help from Gyanendra Pandey's article, that Can a Muslim be an Indian? And he says that in the nation state, along with the nation state, there is one core and the other is periphery. So the core and the periphery is very important to understand. The minority and the majority is very important to understand. That core is an artificial construct, that a nation has a core, has core idea, core values, core culture. And there is other, there is a minority, and they both are mutually constitutive. The majority constitutes the minority, and minority is not a neutral categories. When we say minority and majority, it denotes something. And in Julia Ickart's terms, it denotes a religio-cultural complex. So there is a majority culture, there is a core culture, there is a core religio-cultural complex, and there is the periphery. And the problem and the crisis in the post-metaphysical world is defining yourself, how you define yourself, how you define India, how you define Hindu. So in order to define yourself, you have to look into the other. So other is very important, and othering is important. Othering is a perpetual phenomenon, is a perpetual project, is a perpetual exercise of a nation state. So Muslims are the perpetual other in India. And I would come to that, how Muslims are the perpetual other in India. For example, I will now substantiate that with the definition of Hindu, how Hindus are defined in the Constitution and in the Hindu Code Bill. So first of all, in the Constitution, if we go to the Article 25, which is the very celebrated article, which ensures right to freedom of religion and freedom of conscience and freely to profess, practice, and propagate religion. The same article clause B, that providing for social welfare and reform, or the throwing open of Hindu religious institutions of a public character to all classes and sections of Hindus. So what it says is that nothing in this article shall affect the operation of any existent law or prevent the state from making any law providing for social welfare and reform or throwing open of Hindu religious institutions. So it recognizes a particular religion. It talks of secularism. It talks of freedom of religion and conscience, and to freely to profess, practice, and propagate religion. It kind of suggests that the state is distancing itself from religion. But in the same article, it says that the state can make laws for social welfare and reform of a particular religion or throwing open of Hindu religious institutions of public character to all classes and sections. And it at the same time defines the word Hindus. And according to it, the reference to Hindus shall be construed as including a reference to persons professing the Sikh, Jain, or Buddhist religion, and reference to Hindi religious institutions shall be construed accordingly. So, I mean, the Constitution's Article 25, that is under the Fundamental Rights chapter, itself defines Hindu in a term which shows that it excludes only Muslims, because the other, who is not included in the definition of Hindu in the Constitution, are Christians, Jews, Parsis, and Muslims. So Christians, Jews, and Parsis are a very small minority, which a very negligible minority in India in terms of numbers. So it is always Muslims who are not Hindu. And this is how the core culture is being defined or determined, because the state is ready to distance itself from religion. It is making a very defining feature of secularism is to distance from religion. But at the same time, the state is saying that it can make laws, it can impose laws that provide for social welfare and reform for particular religion. And the particular religion is not only Hindu, but it incorporates Jain, and it incorporates Sikhs, and it incorporates Buddhists as well. Despite the protest from these communities that we are not Hindus, still they are included into the definition of Hindu. At the same time, in the Hindu Code Bill, it is not only limited to this definition. There is a negative definition that the Hindu is anyone who is not a Muslim, a Christian, a Jew, and a Parsi. So again, Hindu, there is a negative definition of Hindu as well in the Hindu Code Bill, and we can see in Hindu Marriages Act how Hindu is defined. I mean, anyone who is not a Christian, a Muslim, a Jew, and a Parsi is a Hindu, and all the rest of three religions are a negligible minority in India. So it is again, Hindu is the one who is not Muslim, and this is how a core is being construed in our constitution and in our laws. At the same time, a non-practicing Hindu, a non-believer, an atheist, I mean, the law at the same time gives protection to them, at the same time give rights to them, and at the same time do not recognize them. I mean, a non-believer will be a Hindu, a person who is not orthodox, who is not practicing Hindu tradition, who does not subscribe to Hindu spiritual heritage, is still a Hindu in the eyes of law. So this is how the core and the other is being constructed through the law, through constitution. So this was the first article, and then next the freedom of religion article, where Hindu is defined in terms as we saw now. And the next is, for example, we could see in Article 48, the directive principles of a state, and a state is being directed to protect caste slaughter, and also, I mean, protecting caste slaughter is not only Hindu. I mean, it is upper elite Brahmanical Hindu. I mean, the element that it suggests is that the constitution recognizes the practices and ethos and values of upper caste Brahmins, because slaughtering cow was very common among Dalits, and this is what Kanche Laya also discusses while critiquing this particular provision regarding prohibition of cow slaughtering. So again, in Article 48, there is I mean, we can see how it recognizes a particular culture. It recognizes a particular religion as the core religion of India. Similarly, in Article 343, Hindi as the official language of India. So what I said is a culture is at the same time religion and religio-cultural complex. So Hindi as the official language of India, and we know the slogan Hindi, Hindu, Hindustan. So Hindu is becoming a monolithic community, and at the same time, a particular language imperialism, Hindi imperialism, is being recognized, is being invoked in the constitution itself. And there was a lot of discussion in the Constituent Assembly that Hindi should not be made the official language of the union. Already the union is strong. Union is the structure, the political structure of the country is a strong union and very weak federal units. So at the same time, it promotes Hindi imperialism, and there were discussion from Tamil speaking people, from Malayalam speaking members of the Constituent Assembly, that this is Hindi imperialism. At the same time, Mahatma Gandhi was the one who was campaigning for Hindi, and he made a Hindi Prachar Sabha that the Hindi should be made the national official language of the union. And this was how the Hindutva was getting legitimacy, because Hindutva was not only about religion or a spiritual tradition. It was a very modern phenomena, and it was it was basically propagating and advocating one monolithic national culture. So one language. I mean, in modern terms, how language is important and how language plays a role in making a culture. So it served when Constitution recognized Hindi as the official language of the Union. So we see that Hindutva ideology was being reflected in our constitution through these articles, Article 1 and then Article 25, where Hindu is defined. Hindu is such a broad definition of Hindu. I mean, and in negative terms, that Hindu is everyone. So Hindu is equal to Indian. I mean, Hindu and Indian is unnecessarily distinguished. It is always Hindu and Indian is always one. If we look into the spirit of the constitution, into the text and how it came into being. So, I mean, again, Sanskrit was also one of the Article 351 of the constitution, I think, says that Sanskrit should also be promoted. And not only Hindi language, but Hindi in Devanagari script. The constitution says that Hindi in Devanagari script should be promoted as the language of the union, official language of the union. So, one language, one culture, and this culture was actually the Brahminical culture. One language, one culture, and one community. This is how the core of the nation is being constructed, and law and constitution is playing a very important role. And at the same time, othering is also happening, and I will come to that as well. The next part is what happened at the founding during the founding moment when the nation was being conceived, and we know that India proposed that there should be just soli, I mean citizenship by birth. But we know what happened with the Evacuee Property Act. The Muslims who left their property during the partition violence were recognized as, or were described as, evacuees, and the Hindus who left their property or their places were called displaced. So the language itself tells a lot. And then when the exodus of refugees, Hindu and Sikh refugees from Pakistan, they came with a kind of, a moral sense, a moral claim, moral ownership over India, and they occupied Muslim properties. And in fact, in many cases, Muslims actually did not left India. They were displaced from that place due to violence. And when they came back, they saw that their property is already gone. And when they asked the government to come in to restore their property, what happened, we know that the police officials were not ready to side with Muslims because they had a natural sympathy. I mean, the word is that they had a natural sympathy with Hindu and Sikh migrants coming from, or the refugees coming from Pakistan. And the government passed the Evacuee Property Act, that government can occupy any property, can declare any property as evacuee property, and then it can use it to resettle. I mean, it can resettle it for Hindu and Sikh refugees. So Muslims were the evacuees, and when they came back, I mean, the police was not, the police or the state was not ready to side with them. And there was a strong sentiment among the mass as well, among the state as well, that they have a natural claim over this. I mean, India is a homeland for Hindus. And the undertone was that where would Hindus go if not to India? And it was also in the Constituent Assembly when one from Sindh, and if this is the principle of citizenship, that citizenship by birth, so where would I go? And the very natural answer that came from the Constituent Assembly members, including B.R. Ambedkar and C. Raja Gopalachari, was that of course India. So every Hindu who was in East Bengal, East Pakistan or West Pakistan was considered to be the potential citizens of India, and they would come here and they have a natural claim to India. So India is a Hindu homeland. This was reflected in Evacuee Property Act. At the same time, it was reflected in how the violence was controlled. Since in India, the violence was against Muslims, and in Pakistan, the violence was against Hindus. So the Nehru Liaquat agreement, or the intergovernmental agreement between India and Pakistan was that since the majority of police and military forces here is Hindu, and they are not in any case protecting the minorities, the military evacuation organization was made, and Muslim army came from Pakistan, from Balochistan to Punjab, to East Punjab, to protect Muslim minority, and from India, from Punjab, military, Hindu military went to Pakistan to protect the Hindu minority. Clear sense that Pakistan is for Muslims and India is for Hindus. So this argument from the secular liberal forces that India will become a Hindu Pakistan, it was there. I mean, it was at the founding moment. It was conceived as a Hindu Pakistan or a Hindu homeland. So military in terms of women, I mean, the crime, the sexual offenses against women, it was very rampant during the partition violence. And what happened? That India would protect. I mean, the pact was that India would protect Muslim women, and the Pakistan would protect Hindu women. And the pact was like this. And what happened if even Pakistan, a Hindu woman is being attacked or is being sexually attacked, abused, she will report to the Indian High Commissioner in Pakistan, and he will then speak to the Pakistani officials, and then to Pakistan External Affairs, and things will go in this way. That if the victim is Hindu, it must be reported to a Indian High Commission. In India, if a Muslim woman is harassed or is abused or is violated, so she will now report to the Pakistani High Commission. So the things were very clear at the founding moment. Similarly, the permit system was introduced, and Muslim coming from Pakistan were given a permit for permanent return, but a Hindu coming from Pakistan was given a permit for resettlement. So we can understand what these vocabularies denote. I mean, what is going on? I mean, the political underpinnings and of these vocabulary is very clear. That Muslims are coming. I mean, they are coming for permanent return. But Muslims are coming, so they are given the permit for permanent return. But when Hindus are coming, they were given the permit of permit of resettlement. Similarly, if what happened under Article 19 of the Article 9 of the Constitution, if you take a passport of a different country, your citizenship is gone. I mean, you are no more an Indian citizen. So if a Muslim who went to Pakistan, he gets a Pakistani passport, now he plans to come back to India, so he will become a citizen through registration. He will register, but the official correspondence among the secretary and home secretary and external affairs secretaries at the immigration department, I mean, was very clear that Muslims coming with a Pakistani passport must be scrutinized well, must be confirmed from the intelligence bureau, and this. I mean, there are so many checks to anyhow make it impossible for him to become an Indian citizen. But if a Hindu is coming with a Pakistani passport, so the members and the leaders then were discussing, and the correspondence we have denotes that documentation is not important, intention is important. And it was said that Hindu is coming, it means he's coming to resettle in India. And this is how the officials at the border, at the immigration, carried out the instructions from their political leaders. So this is what happened at the founding moment. This is what is in the Constitution. And now when we go forward, we have the Hindutva judgment. And it is important to understand the Hindutva judgment as well, because which is very important judgment. What happened that in Maharashtra, Shiv Sena and BJP fought election, and the election was in Maharashtra Assembly. The election was challenged, that the candidates who won, they during the election campaign appealed to a particular religion and incited hatred against Muslims, which is prohibited under the Representation of People's Act. And then court was not only lenient to these hate speeches, but also defined Hindutva in a very secular term. And this is a very important turning point in Indian legal history. I will just read out the speech, one of the speeches which were challenged in early 90s. So the speech is that Manohar Joshi was one of the candidates, and his speech is, quote, "The result of these elections will not only depend on the solution to the problem of food and clothes, but also whether in the state of Maharashtra, the flame of Hindutva will grow or will be extinguished. If in Maharashtra the flame of Hinduism is extinguished, then anti-national Muslims will be powerful and they will convert Hindustan into Pakistan. If the flame of Hindutva will grow, then in that flame the anti-national Muslims will be reduced to ashes. Rajiv Gandhi, the then Prime Minister of India, speaking on Hindutva is like a prostitute lecturing on fidelity. The country is again headed for partition. It is therefore necessary that in these circumstances and to keep the flame of Hindutva alive, the alliance of BJP Shiv Sena should be elected." So this was the speech, unquote. This was the speech by Manohar Joshi, which was challenged in the Supreme Court. And Supreme Court was like, not only said that this speech was not prohibited under the Representation of People's Act. What they said is that the word Hindutva is in an election campaign did not produce religious enmity and hatred in violation of the provisions of 1958 Act, but simply represented a way of life of people of the subcontinent rather than an attitude hostile to persons practicing other religions or an appeal to religion. The term Hindutva is related more to the way of life of the people in the subcontinent. It is difficult to appreciate how the term Hindutva or Hinduism per se in the abstract can be assumed to mean and be equated with narrow fundamentalist Hindu religious bigotry. And the court also said that the speech was and the use of the word Hindutva might be used to promote secularism or emphasize the way of life of the Indian people and the Indian culture or ethos and to criticize the policy of a political party. So now court not only legitimized this is the use of term Hindutva, but also it kind of detached Hindutva from religion. So now there is a new secularism which is Hindutva, which the court says that might be to promote secularism. And it said that it's a way of life that the subcontinent, people of the subcontinent practice or profess. So which means that the court is legitimizing it giving it a legal force to this idea that Hindutva is basically a culture of the subcontinent. The Hindutva is Indianness, is secularism. So the new secularism is Hindutva, and then that gave a very strong a kind of a strong support to the Hindutva ideologue, and they used this judgment and they kind of got a legitimacy from the court of law that their ideology is basically secularism, and they always kind of questioned the idea of secularism because they said that this is not secularism, this is Muslim appeasement, and actually secularism is that is the Hindutva way of life. Secularism is Indianness, is Hindutva. So this judgment was an important turning point in the legal history of this country. While on the other hand, in S.R. Bommai case, the court kind of attacked Hindutva ideology, kind of attacked RSS and VHP, and upheld the proclamation of a state emergency in 4 states where BJP was the ruling party after the Babri Masjid demolition. But when Ismail Farooqi appealed in the Supreme Court, went to Supreme Court against the Ayodhya Act. According to Ayodhya Act, the land in Ayodhya was taken over by the government, and it was proposed that in 67 acres of land, a mosque will be built, a temple will be built, a museum will be built, a cultural center will be built, etc., etc. So he went to the Supreme Court and asked that this is against secularism. This is anti-secular because a mosque was illegally demolished and it must be restored. And what Supreme Court said in the judgment, it first applauded the Hindu philosophy, the tolerance it promotes, the Hindu philosophy, how Hindu philosophy led to the foreigners coming to India and getting shelter here. So first they applauded the Hindu philosophy, and then they went on to define define what amounts to religious practice. And they said that the right to practice religion, or the freedom of religion, means freedom to practice essential part of religion. And offering namaz is an essential part of religion, but offering namaz in a particular mosque or at a particular place is not an essential part of religion. So it upheld the Ayodhya Act, and a kind of gave legitimacy to the demolition of Babri Masjid. And demolition and destruction of Babri Masjid became fait accompli. So these are the important turning points in Indian legal history. There, on the one hand, you have a Sar Mumbai case, but on the other hand, you have the Hindutva cases. On the other hand, you have Ismail Farooqi case. On the other hand, you have 2010 Allahabad High Court case and the 2020 Babri Masjid case. I would not complicate the judgment, the Babri judgment. It's simple. The court says it was illegal, the demolition was illegal, and when the idols were placed in 1947-49, it was illegal. And in talking about secularism and in the illegal act and criminal act of demolition and everything, and there is a kind of a cognitive break in the judgment. Ultimately, the flow is broken. I mean, it was illegal, and it talks about secularism, and then suddenly it changes. It takes a radical turn and justifies the demolition and allows Hindus to construct a Ram temple there. Now, the important part is not is not only that the judgment was flawed or the judgment was pro-Hindutva. The important part is how Ram became the uber god of this country. This is how Hindutva, the actual success of Hindutva lies in becoming of Ram as an uber god and becoming of Hindu religion, casting Hindu religion in Abrahamic framework. It becoming a monotheistic religion because in India, people were practicing different spiritual tradition. Every community, small community, regional community, had their own god, and there was no idea of one god. And we know in the post-Babri election, when Mayawati and Mulayam Singh fought election together, the slogan was ke mil gaye jab Mulayam aur Kashi Ram hawa mein ud gaye, Jai Shri Ram. So that was then, because they said that we worship Krishna, and there were so many, even thousands of gods in this country, and every small regional and regional community had their own god, had their own which they worship. But the success lies in how Hindutva homogenized things and made Ram as an uber god. And the court gave the legitimacy to this, that in the Ismail Farooqi case as well, in 2010 judgment as well, and in 2020 judgment as well, that is a place where Ram is the one which Hindus of this country worship. And when they say Hindus, it means Hindu as a monolithic community, hundreds and thousands of Hindus, every Hindu. So this is a success. This is the modern evolution of Hindu, Hindu becoming a political community, and casting a particular polytheistic religion into an Abrahamic framework. So we miss this point sometimes, that the actual success of Hindutva not only lies in that they are allowed to build a Ram temple. The actual success lies in how they are successful in portraying Ram, in making Ram the uber god of this country, and homogenizing Hindu culture and Hindu religion. So this totalitarian, this homogenizing tendency of Hindutva succeeded in Babri judgment as well. Now I would like to discuss some about security jurisprudence in India. And what is important about security jurisprudence is it has been one of the most important tool of othering of Muslims in India. And liberty and security is one of the most important element in the conception of modern state. The modern state is supposed to ensure security and And the challenge before a modern state is to strike a balance between liberty and security. But through this, I would say that through the security laws and security jurisprudence, a kind of the us and them binary has been consolidated in India, and everywhere it happens. And how it happens, we will look into it. But first of all, we must understand that how important is the idea of crisis is in modern thinking. Um, in a post-metaphysical world, we do not have any inspiration to act when the decisions are made, how to make decisions, how to mobilize. So crisis is the moment of truth that determines is the turning point of history, that determines our decision, that determines our action. So Muslims are the perpetual crisis of this country, are the perpetual emergency of this country. So the emergency legislations were supposed to be used against, or to be used on the emergency community of this country. I say the emergency community, which is not a proper word, but just to denote that since there is uh, no higher moral framework for a state, for a modern nation state to look forward to. It is the crisis that determines the history, and it's the crisis which suggests the moment of truth. So Muslim is the crisis community, is the community, is the emergency community. And uh, in respect of crisis, the telos, uh, of the crisis, when we say that this is a crisis and we make decision, it is always triggered towards a norm. So it is always the crisis that determines what is normal, and it is always the Muslim which determine who is an Indian, who is the core self of this country, who is how the self is determined in this country. First thing. The second thing is that it always, in determining norm, when we say there is a rule of law, we must also tell that what is the other of the rule of law. This is normal, then what is abnormal? What is extraordinary? So, so there is always a dual law system in every modern nation state. One is for the normal people, one which deals with the normal people, which deals with which deals with the self, with the core of the country, and the other that deals with the other. And there is rule of law in the normal sphere, and there is rule by law in the extraordinary sphere. So Muslim is the one which cannot be assimilated, is the one which can never be loyal, which is one which do not belong to the core culture of this country, which 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 is which is radically different, and uh, which is uh, which is the other. I would say the other, which determines the self of this country. So there was always two types of law: the normal law, the rule of law. For example, that no one should be denied liberty and right to life and livelihood. No one should be incarcerated. No one should be detained. Everyone who is detained must be produced before a magistrate within 24 hours, and no one should be denied right to life and liberty unless by the procedure established by law. Bail is a right. There are so many rule of law principles for normal situation, for normal sphere. But at the same time, the constitution, where it says that no one should be denied right to life and personal liberty, and everyone should be produced before the magistrate. Who is arrested must be produced before the magistrate within 24 hours, allows for preventive detention, where you violate, where you sidestep all these rule of laws. And when we see where these uh, uh, these exceptions were used, so the state of exception is very apparent when we look into three anti-terrorism laws in India. First is TADA, the terrorist activity, and then POTA, Prevention of Terrorist Activity, Prevention of Terrorism Act, and then we have UAPA. So TADA was invoked in 1985 to control, to check the growing uh, insurgency Khalistan movement in Punjab. And then it was used all across India. And what Tada provided that in normal circumstances, confession before a police officer is not admissible, but under Tada, a confession before police officer is admissible. In normal circumstances, no one can be could be put into just judicial custody for more than 90 days, unless a charge sheet is filed. So remand period is 90 days. But in Tada, it was 1 year. In normal circumstances, bail was a right. In Tada, bail was not a right. So these were the departure from the normal cases were tried in a normal in a regular criminal court. The Tada cases were tried in a Tada specialized court. The normal cases were tried in an open court. In Tada, the Tada cases were tried in a closed in-camera proceeding where the witnesses were protected. What happened with all these? That you cannot claim you don't have a right to you can be detained without charge for almost a year under Tada. Now, when you go for bail after 1 year, the court will ask the accused to prove his innocence, because it provides that if the court is of the opinion that the charges against you are prima facie true, it will deny bail. So it will give an opportunity to the prosecution to prove to contest the bail application, and if the accused fails to prove that the charges against him are not prima facie false, the bail will be denied. So what happened that jail was the rule and bail was an exception. Nobody got bail in Tada cases, and same happens in Kota and same happens in UAPA. So in Tada cases, it was first it was used against Sikhs in Punjab, and then across India it was used against Muslims. So much so that in 3 states, more than 2/3 of cases were against Muslims. There were 19,000 Tada cases in Gujarat which had no militant activity. It was used against Dalits as well. For example, after Babri Masjid demolition, Tada was, and there was a chain of riots in India, and then there was a bomb blast in Mumbai. So there was an urgency in the bomb blast case, and many Muslims, hundreds of Muslims were booked under Tada. And the cases of Bombay bomb blast are still ongoing. There are a few cases. And at the same time, there was a demand that Tada must also be invoked in against those who are accused of anti-Muslim riots in Bombay. And what happened? That the police said that we do not have evidence, and the files were noted. It was noted on the files that the allegations are true but undetected. So the files of Tada cases in anti-Muslim Bombay riots were marked with true but undetected. Similarly, under Tada, until September 1994, 409 out of 432 people arrested under Tata in the state of Rajasthan belonged to a minority community. It was applied with such bias that even India's Minister of State for Internal Security admitted that Tada had been extensively misused against Muslims. So, I mean, it was extensively used against Muslim Tada. And similarly, Kota, it had all the same, it had similar provisions, and it was used against Muslims. And we know how UAPA is being used against Muslims. And under Kota, for example, in Kota cases, when Kota was introduced in Parliament, what was the justification for bringing in Kota or Koto? First is that the report observed that that there is a religious terrorism, rise of religious terrorism in India, and they cite the Bombay blast of 1993. But the crackdown on the Muslims in Bombay did not amount to terrorist activity, or the demolition of Babri Masjid was not considered a terrorist activity. Similarly, under Kota, I think the very important data relating to Kota is that out of 280 individuals charged under quota in Gujarat, all of them except one were Muslim. I mean, out of 280, 279 were Muslims. I mean, people charged in Gujarat, 280 individuals charged in Gujarat, 279 were Muslims. There are so many cases where quota and quota was used against Muslims, specifically in Gujarat, and uh, the rate of conviction in all these cases, in Tada cases and Quota cases, in Tada it was less than 1%. The 77,000 people arrested under Tada, only 7,000 were tried and only 700 were, less than 700 were convicted. So it shows that it was only used to harass Muslims or to harass the minorities, to harass Sikhs and Muslims. It was used to other them, to marginalize them, to push them to the wall. Similarly, in Kota, the rate of conviction was very low, and it also had draconian provisions, and it was used against, especially against Muslim. And I would cite one example. What happened in Gujarat? Before the Gujarat riot, there was a Godhra carnage where Muslims were accused of burning the Godhra Express, the sleeper bogie of Godhra Express, and there was a riot, a pogrom against Muslims in Gujarat, where thousands of Muslims were killed and looted, and women were raped. So what happened first, that Muslims accused of the Godhra train carnage were booked under quota. But there was a demand that those who are accused of anti-Muslim program in Gujarat must also be booked under quota because it was a terrorist act. The program was a terrorist act. And what the government suddenly did, that it revoked quota, or it surrendered quota from against which was invoked against the Muslim accused, so that it can protect the accused, protect the anti-Muslim program accused. I mean, the Hindus who were accused of anti-Muslim program in Gujarat, so that it can protect them. It surrendered, or it withdrew the quota from Muslims as well, those who were accused of the Godhra train carnage as well. And after 1 year, when almost all the accused of the Gujarat program were released on bail, the government suddenly invoked quota again on the Muslim people accused for the Godhra carnage. So this is how the government misused these laws against Muslims. Similarly, in UAPA, the important case under UAPA is the SIMI case, how the SIMI was banned. And SIMI was banned in 2001, and hundreds of students and young SIMI members were arrested from India. So when you ban an organization under UAPA, it must be put before a tribunal to justify the ban. I mean, you get an opportunity to defend yourself. An organization which is banned gets an opportunity to defend itself before a tribunal. So from 2001 to 2019, 8 times the SIMI has been banned, and almost all the times except 2008, the ban was upheld. In 2008, the ban was said. It was said that no new cases are there against SIMI people, and you bring in the old cases which were before 2001. So the ban is not justified, and it must be revoked. Next morning, the state appeals against the tribunal judgment in Supreme Court, and Supreme Court upheld the ban. But what happens after 2008? When in 2010 the SIMI is again banned, because every 2 years the ban must be reviewed. So when in 2000 the ban was again renewed, the state came before the tribunal with new cases, and in 2012 again with new cases, and most of the new cases were coming from from Madhya Pradesh, where no militant activity or no terrorist activity happened. So what happened in Madhya Pradesh? So the study shows that in Madhya Pradesh, many many young members of SIMI were arrested on on whimsical grounds. For example, they were shouting slogans, they were distributing SIMI magazine, they were distributing SIMI pamphlets, they were doing this and they were doing that, and similar charges were imposed, or similar charges were framed against almost several members arrested from different places in Madhya Pradesh. For example, same edition of magazine was produced as evidence against 4 different accused people And in one of the cases, the superintendent of police writes to 13 districts that file cases against Simi people. And all these districts administration files cases against Simi people so that they can justify the ban. This is guilt by association. And same allegations that they were distributing pamphlets, they were distributing magazines, Simi magazines, they were shouting anti-India slogans, and sometimes they criminalized religious practices. For example, the particular accused was giving dars, was giving Juma khutbah, was giving this is I mean the general Islamic religious practices. He was organizing religious zikr circles or like that, or he gave a Juma sermon. So these religious practices were criminalized in the tribunal. And also along with that, in Simian tribunals, they produced secret documents, sealed cover documents, and most of the time it was the two evidences produced were the secret documents and police officials. They came to the tribunal from different states with the confession of Simi people that they confess that they are doing this, and on grounds of this confession of Simi members and secret documents, ban has always been upheld except 2008. And after 2008, new cases came before the tribunal, and these two new cases were on the face of it framed. And it not only shown how cases are framed against Muslims, but along with that, it denotes that how religious practices were criminalized. So what I am trying to say is that through security jurisprudence, through the text of the law, through constitution, through court, I mean, Muslims have been othered, and this phenomena can never be captured through the vocabulary of secularism or communalism. The crisis lies in defining itself. I mean, how India defined itself, and in terms in course of defining itself, it has constructed the other, which is Muslim, and especially in security jurisprudence. Uh, when you say that the threat is imminent, the terrorists are everywhere, and it's a transnational network of terrorism. What happens is that you racialize the threat. I mean, what happens is that police officials this stop and search, this sneak and peek, and this data collection, this biometric. These are not neutral things. I mean, stop and search is a very racial activity. I mean, they are left with only one option is to read your body. I mean, to read a mark of suspension, read your body as a mark of suspicion, because threat is everywhere, is imminent, and the only way to 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 check terrorism is to racialize the problem. That anyone who has beard, who wears a skull cap, is a terrorist. So I mean, this is a part of the story. I mean, it's uh, very much embedded in our legal political praxis of this country, and we have to understand that that our site of struggle is not only legal, that our site of struggle is not only political, but our site of struggle is epistemological. This othering, this hijacking of our right to self-define ourselves, our right to self-define ourselves, that we cannot be stereotyped, we cannot be generalized, and no one has the right to portray us, to represent us, except us. And our expression, our articulation of our experience is important, is relevant, far more relevant than someone else representing us, than someone else defining us, than someone else telling us that they are violent, they are extremists, they are terrorists. So this fight is epistemological, not only in terms of restoring our subject position, but also in order to participate in this crisis, the crisis of defining oneself. How a modern nation state is trapped, how a modern philosophy is trapped, that it has to is bound to define itself through othering. And racism is a modern is not only uh, is is inevitable. In a modern political imagination, racism is inevitable, and we need to not only say that we will go to court and we will make it a site of a struggle, or we will make a political mobilization, but at the same time we must have to critique and to review and to challenge and question the conception of the modern nation state, the idea of the modern political, the 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 crisis through which the modern political philosophy or the modern philosophy is dealing with. So the task is not only to protect ourselves, but is to participate in the struggle of how we conceive, uh, uh, how we draw boundaries, how we draw political boundaries, how we define political community, how we define membership, how we define refugees, how we define territory. I mean, we have a big task before us, and we cannot restrict ourselves to just going to court and talking about our making court as our site of struggle. So there are so many things which are there which we could have discussed, but just few things I wanted to say. I mean, one more thing is important when we look into the terrorist cases and the judgments that came. What is important to look is that the judgments are actually producing knowledge about Muslims. They are making representation. They are stereotyping. They are kind of representing Muslims. So it is important you know uh, to understand how knowledge is being produced through the institutions of law. That, for example, when court says in one of the Kota cases that there is rampant terrorism everywhere, and the terrorism is being carried out by religious fanatics, and is a radical and extremist explanation of religion that leads to terrorism. So, which religion the court means there? I mean, what court is signifying, what court is denoting, is that it cites three cases of terrorism. One is World Trade 9/11, the other is an attack in Russia, and the third is the Parliament attack. And all these attacks were carried out by Muslim fanatic organizations, which we know. So when court says that this is done by religious fanaticism, it is producing knowledge about a particular community. When we look into the charge sheets in UAPA cases, in Kota cases, the charge sheet is very clear that he was introduced to jihadi literature. He was introduced to Quran, that there is a lot about jihad in the Quran. He listened to particular Maulana. He listened to particular Mulvi. He got to know about the rewards of jihad, about shahada, and this and that. So what court is doing is not only just disposing of the case, is not only adjudicating a particular terrorist case, but at the same time producing knowledge about a particular community, is trying to represent a particular community, not only the community, but a particular philosophy, a particular ideology, a particular religion. That this religion has in its philosophy radicalism and extremism and jihadi things and that. And we do not get the opportunity to explain what jihad is. We do not have the right to explain what we understand with jihad. We do not have the right to defend our subject position. We do not have the right to say, to articulate our subjective experience. So it is important to not only fight that we must be treated equally. It is important to regain, to reclaim our right to self-define ourselves, our right to defend our subject position, to our right to articulate and express our subjective experience, and to claim that our voice, our articulation of our subjective experience is far more relevant, is not only far more, is relevant, is the only relevant expression of our subjective experience. So I would like to conclude this, and I would say that my talk was very ill structured and not well organized and prepared. I'm sorry for that.
Absolutely not.
Questions are welcome.
I completely disagree with your conclusion about your talk not being structured. It was very fascinating. One particular statement struck a very raw nerve, and I just want to repeat that statement. And please tell me if I have understood it wrong. 77,000 charge sheeted, of which 7,000 went to trial, of which 700 were convicted, who would have otherwise been convicted with existing laws against violent crimes.
Yes.
Is that correct?
Yes. So the data is like, just a second. Yes, according to the Union Home Ministry report of 1993, a total of 52,268 detentions were made under TADA, and the conviction rate in trial was less than 1%. In Punjab, it was 0.37%. Of 14,557 persons detained, whereas in Gujarat, it was only 0.9%. The overall figure is more disturbing. Out of 77,000 people arrested under this act, only 8,000 were tried and a mere 725 convicted, implying that around 70,000 people were unnecessarily detained under TADA. So this is the data from the Rohit Prajapati's article, and the TADA Review Committee admitted that it was wrongly applied on 50,000 people. The government constituted TADA Review Committee also admitted that it was wrongly applied on 50,000 people. And there is Amnesty report, there is Ubaidur Rahman's report, and
all of this actually, I know usually discussions like this, not only does it enlighten us because we understand the seriousness of the problem, and it is unfortunate that there is a very large section of Muslim professionals who exert a lot more or who exert disproportionate influence in terms of narratives and in terms of representations and even influence, actually are neither aware of these structural issues, and unfortunately, maybe the word parrot is a wrong thing, but also seem to somehow are complicit and agree with the overall narrative against, with Islamophobia being a random act. One, number two, it's something that we've actually more or less deserved and actually have invited. These are usually issues that need to be always at the front, but it also makes it look very bleak as to what the outlook is. Like, for example, there are two questions that are there on the chat, and I'll read them for the benefit of everyone. I would argue that it is more or less the same question, but on two levels. Like, for example, number one is a very direct tactical reference about, is the Congress really a savior party for Muslims or less evil than BJP? And if not, why does the majority of Muslims believe so when Muslims are socially and politically weak since the very beginning? And the second one is, can this, when I say, well, so the second question is the second level, is can this epistemological fight be fought within the boundaries of the nation state, which clearly you've shown how stacked against the odds are, and if not, what are the alternatives to not only nation state, but like a practical solution to this?
the second problem is it's actually important, the epistemological fight, and within the nation state framework, it is very difficult, and we have to find the blind spots of modern political imagination. So the boundary is one of the very important blind spot of modern political imagination: territory and refugee. So when you actually engage with these blind spots of modern political imagination, you get an opportunity to epistemologically struggle or to epistemologically engage with your problem as well. So the first and foremost thing is to point out, is to identify the blind spots of modern political imagination. For example, I said that refugee is one of the, and you have to begin from that blind spot, not from the very given the strength of modern political imagination. You cannot start from constitution, you cannot start from rights vocabulary, but you have to find a different vocabulary. You have to come up with a different framework, and for that you have to find the blind spots. There are scholars in the world who are of course not Muslim, but they are approaching these blind spots from a different epistemology and different epistemological positions. So from a Muslim perspective, I would say that it is important to identify the blind spots. What happened is that in terms of institution, in terms of infrastructure, in terms of institutions, the modern philosophy and modern political imagination is very strong. I mean, when you go there, being a Muslim, they will say, oh, if you want to bring Sharia, we have democracy. You want Khilafah, this is Khilafah, and this and that. So yes, democracy is an institution, but they have, but the very foundation of modern political imagination that rests on certain assumptions, you have to challenge those assumptions. For example, Hobbes come up and he has an assumption that men are human beings are selfish and violent, and there is a war against everyone against everyone. I mean, they are selfish and they are nasty, brutish, and short. And this is the assumption on which the modern state is standing. So we have to approach that assumption. We have to problematize that assumption. Similarly, for example, I would say, I mean, emergency legislation. What is a state of exception? When you say that there is a rule of law, what does this state of exception signifies? And you have to approach this state of exception, this emergency legislation, or the rule of the state of exception. And this is a modern blind spot. The question of sovereignty: who is sovereign? The sovereign is constituting law. The law is constituting sovereign. They are mutually constitutive. So these are the fundamental assumptions of modern political theory and modern political imagination. The epistemological fight has to begin from these blind spots, problematizing and engaging with these blind spots, not playing with their strength, not playing in their field, but in their weakness, and then from there we can continue our struggle.
So you mentioned about legislations and spoke about TADA and POTA and UAPA. Was there something? So what is what maybe very quickly, Azam, if you can tell us the not the chronology, but the rationale for one having succeeded the other. So why TADA came up because of this, and then maybe and is it POTA came because TADA couldn't do this, and therefore POTA came, and UAPA came because POTA didn't do that, and what's a very quick answer to that?
Yeah, because TADA came in the backdrop of Punjab insurgency in the Khalistani movement, and it came as an emergency legislation that there is an emergency in the country, and we need to sidestep the rule of law procedures and the rule of law standards, and the situation demands some compromises with liberty and rights. You have individual rights. So TADA came up with that, and every emergency legislation says that it is for a temporary period. It has a temporal significance. Once the emergency is finished, the law will go. So TADA came up in 1985. It was for 2 years. In 1987, it was reviewed in the parliament and it was restored. It was upheld. In 89, it was upheld. In 91, it was upheld. In 93, it was upheld. In 95, it was allowed to lapse in the parliament, not upheld by the parliament, because the National Human Rights Committee requested the government that TADA must go. Otherwise, the question or the talk of human rights is worthless. There is no point of talking about human rights if TADA is there, because it is so much abused against minorities, against Dalit, against tribals, against Sikhs. So it was. I mean, the data shows how much it was abused. So, and after the recommendation of the Human Rights Commission, National Human Rights Commission, and other activist groups and NGOs and international pressure as well, international NGOs as well, the TADA was allowed to lapse in 1995. But the problem is that there cannot be a normal legal landscape unless there is an exception, because the exception is determining the normal. So in 1995, just when the TADA went, the Law Commission recommended the Criminal Law Amendment Bill, and in 1999, the government asked the Law Commission if there is a need for a special legislation to fight terrorism, and it has to be. I mean, emergency must be perpetual in a modern political imagination. So yes, they came up that there is emergency and we need a counterterrorism law, a special law, and POTA came. POTA also went because there was rampant abuse of this law against minorities. It was being used as a political tool. We know Vaiko in Tamil Nadu was booked under POTA. Raja Bhaiya in UP, a political leader, also with a criminal background, was booked under POTA. because he belonged to a different party. Vaiko would belong to a different party. So Puta was misused, and in the government in 2004 when UPA came, it said that we will revoke Puta and it will be repealed. So Puta was repealed, and then in 2004, just when Puta was repealed, UAPA was amended and made a counter-terrorism legislation. And in 2008 again, then there was an emergency when there was 2611 in Bombay. Again in 2008 it was amended. So if we go from 1949, 1950, there is consistently a promulgation of emergency legislation. In 1950 there was Preventive Detention Act. In 1962 there was emergency proclamation of emergency. In 1967 there was UAPA. In 1971 there was MISA, Maintenance of Internal Security Act. In 1980 there was National Security Act. In 1985 there was TADA. In 1995 there was Criminal Law Amendment Bill which could not be passed. In 2000 we got POTO. In 2001 it became POTA. In 2004 we got UAP Amendment 2004. In 2008 Amendment. In 2012 Amendment. In 2019 Amendment. So there was, I mean the norm and the emergency defines and constitutes each other. So there cannot be.
So you're saying that fine. So this is a perpetual state, but different names and abbreviations that move depending on perhaps some contextual issues, and therefore this state will remain as is, meaning the state of exception and emergency and anti-terrorism laws, which historically prove have been misused and abused, and in this case in particular manifests as in Islamophobia because it attacks Muslim minorities. Okay, can I just ask this also? When you say struggle is also epistemological, how do I tell that to someone who doesn't know what the meaning of the word epistemological?
I mean, it's a bit difficult to explain the term epistemology. What I would try my best to explain it. When we say that we are being discriminated and we have to go to the court of law, because in the current framework we have the only option is the court of law. But what happened is that we do not think of an alternate framework where our problem can be understood, our problem can be received and can be problematized. So what happens is that the citizenship, so we say this is violative of Article 14. We say this is violative of Article 15. We say this is violative of the spirit of the Constitution. So we try to remain within the framework given, the current framework, the knowledge framework. So what I mean by epistemological struggle is to take the issue out of the given framework and to bring it into our own subjective framework, or framework, or you can say to problematize it in another way. For example, now you start questioning the idea of citizenship. What is citizenship? And then you try to pick the blind spots in the idea of citizenship. For example, according to a liberal ideology, everyone who is born in a particular territory must be the member of that political community, must be the citizen of that state, and it must be liberal in the sense it must always be open. Whoever wants to come in must come in. But then the dilemma lies in the closure. So where do you close the gate? Who do you exclude? I mean, you want to be very inclusive. You are liberal idea. It must be open for because you do not discriminate. You do not see from the eyes of any category. I mean, neither religion nor race nor gender. You are liberal. You just see individual human beings, and he has a right. But the question arises: where do you draw the closure? Where do you close the gate? What formula do you bring in to close the gate? And that is the liberal dilemma. And that is the point where you have to hit. That ultimately the closure is religious, the closure is racial, the closure is gender specific, and then you try to unpack that blind spot, and that is the epistemological struggle.
So it's saying that so the point is, if there is a law, and laws are meant to be obeyed by citizens, which is the contract between the state and citizenry, if a law that is stacked against you, institutionally against you, and is also when it is institutionally stacked against you, it will automatically be immoral and evil. One cannot say, well, I'm very sorry, it's the law, you have to accept it. So we should not accept it because it is immoral. So a law that is immoral should not be accepted just because it's law, and should be opposed because it is immoral.
And I will give you another example. For example, when Pota was there, when Tada was there, our side of a struggle was court. And the language we used, the narrative we used, the framework we used was that there is a rule of law principle, there are rule of law measures, and this law is against those principles, this law is against those guarantees, this law are against those constitutional safeguards. So we were within the framework of rule of law.
Okay.
But an epistemological struggle would be to ask that why there is a necessity of emergency, a perpetual emergency, to determine and define the norm, the normal.
Yeah.
So this normal emergency going together, this normal defining the emergency, that this constituting emergency and then emergency constituting normal, this phenomena must be dealt from a different paradigm, not from the paradigm, the given paradigm, from which it is coming out. Not going to the constitution and not asking the constitutional safeguard itself, but taking it outside, taking it away from that paradigm, and then problematizing it, that what is actually the crisis, that you cannot define or determine the norm without defining or determining the exception. Why exception is inevitable in a modern political legal imagination. So this is asking questions, problematizing the problem, and breaking away from the master or from the mainstream paradigm. This is what I mean by epistemological struggle.
Okay.
I don't know if I was able to explain myself.
No. I find that it's clear now. I was just trying to understand the train of thought. If there are any questions that that those on the Zoom link would want to ask, I don't know. Either you can use the raise your hand option, and I'm happy to take one more question. I think we are at the end of our session now. So lapse and absence, maybe this could be the last question for now. Lapse and absence of legally fighting the claims and cases are the major cause of Islamophobia. Do you agree?
Sorry, 1 second, sorry.
Yeah. I'm not very sure. So the person, I don't know if I'm allowed to say his name because it came in privately, but so the question is, lapse and absence of legally fighting the claims and cases are the major cause of Islamophobia. I'm not very sure I've understood the way it's typed, but could be. But could that be a part of the fight against Islamophobia? I mean, fighting those cases legally, the ones that are stacked. I know you mentioned that you cannot go to the same paradigm, but would that be part of a strategy against it?
What I wanted to say is that I'm not advocating anarchy here.
No, absolutely not. No, nobody is.
What actually I wanted to say is that yes, the given paradigm, given framework, we must exhaust our options there as well. We must make those sides of a struggle, our sides of a struggle as well. The legal institution, fighting cases, going to courts, coming into elections, making the political, involving in the political struggle. These are all important sides of a struggle. But over and above all this, what I am saying is that we cannot only restrict ourselves in these sides, in these struggles, but also adopt the epistemological struggle. We must also evolve our language, remaining in the constitutional framework. Of course, that is one part of it. But you know, the true articulation of our subjective experience, the true articulation of our problem would be only if, along with all these struggles, we include in our struggle the epistemological framework, epistemological. I mean, we include in our struggle a different framework, a new language, a new narrative.
Okay, so I mean, this will be the final question from us, and given that we're here in the UK, so what's the way forward? What can the Indian Muslim diaspora, at least the ones in the UK, I'm not going to be speaking for everybody around the world, but those in the UK can actually do for impactful, effective actions, and in creating allies against Islamophobia and the fight for it?
I mean, if we are focusing on Islamophobia, Islamophobia is primarily a phenomenon of the West. It is borrowed from there, from the experience of immigrant Muslims in England and US and other European countries. So of course you have to fight Islamophobia there, but being a diaspora, I think advocacy is something which uh, which which occupies a very special place today in 21st century activism. So the diaspora there can, the naming and shaming kind of thing, and doing proper advocacy, approaching international organizations and international institutions. And for example, there is Human Rights Commission. So being a diaspora, building pressure on those international organizations, and building a narrative. I mean, international shaming of a particular government or a current government in your state, in your home country, would be very effective if you could expose its hypocrisy, if you could expose its intention, its ill intentions, and if you could embarrass the government, not the state, the government and its policies on international platforms. That would be a great service to Muslims, and not only to Muslims but to Indians as well. The Indian diaspora who feels, for example, the Sikhs are protesting, the Punjabi diaspora in different countries are protesting against the farm bill. So it is not only building pressure, but it is kind of shaming the particular government, and is kind of exposing their bill, their policies, and their intention. So I think advocacy and building pressure and kind of shaming the government is an important tool today when we have a transnational and international global governance framework.
Fine. Azam, we're now getting questions also from from those who have joined in, and I hope it's okay for you to answer it. So we're going to unmute, and I'm going to ask Shaheen and Azim Shah and Samir to decide who is it that we are allowing to ask the question. It'll be Uzair Ahmad. Uzair, can someone can Azim Shah, can you unmute Uzair Ahmad, please, who's raised his hand and wants to ask a question? I mean, unfortunately, this will be the only question that we can take from those in the audience today. Uzair, can you please go ahead with your question? All right, so he's also typed it. So in the judgment of Babri Masjid, according to you, who is responsible? Is it democracy or judiciary, and why?
I mean, we cannot look into judiciary or how judiciary works in isolation. I mean, judiciary has a great impact of what is happening in society. So judiciary is not isolated, is not aloof from the political tussle, ongoing political tussle, and it is very much evident from what happened during the emergency, when there was a majoritarian government and a strong executive at the center, and emergency was declared. The judiciary was kind of conceding to each and every executive action. For example, in ADM Jabalpur case, for example, the Supreme Court said that all fundamental rights, including the right to life and personal liberty, is suspended during emergency. And when in 1980 that strong executive is replaced with a kind of a very loose political lose what do we say? Uh, 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 a coalition government at the center in the 1980s, the Janata Party government. Suddenly, the judiciary was kind of went into a remorse and trying to compensate the wrongs it did during the emergency, and it became hyperactive, and there was an era of judicial activism and public interest litigation, and judiciary was kind of we say it a judicial overreach there. And then again from 2014 we see that judiciary is again conceding to executive because at the center there is a very strong government, a majoritarian government. And you see that Arnab Goswami case gets an urgent hearing, while the habeas corpus petitions and 370 petition against 370 against other such laws are not being entertained. So the judiciary is kind of conceding to the executive. So this notion or this idea that judiciary is aloof, is isolated from the society, is sacred, is misconceived. Actually, judiciary is very much influenced by the executive and the political landscape of the country.
Okay. Well, I think we can call it a wrap now, but thank you so very much for your time in discussing a very, very, very important subject, and also for enlightening us on things that I would argue quite a lot of us had not necessarily thought of before. So on behalf of StriveUK, we thank you and everyone who joined us today for the session, and hope we can continue to not only have these sessions but also play an important and essential role in the activism against Islamophobia, with one of us with one of the symbols being to reclaim and recall Babri Masjid. So thank you so very much, Azam, for your time, and thank you to all who have joined. And the webinar will now be concluded. Thank you very much.